Hi students, today's lesson is Statutory Provisions for the Elderly. The lesson is about legislative and constitutional provisions of the elderly in India. The purpose of the text is to describe the legislative measures and discuss the various constitutional provisions for the elderly in India. Senior citizens are the treasure for our society. They are a link of past, present and future. As they lived their life, they saw past and pace of progress throughout their life. They are in a better position to evaluate the present and predict about the future. They are the senior members of the family who know better about the religion, family history, values and related customary practices. They possess better understanding of the family values and society. They pass these family values and societal knowledge to the upcoming generations. This was an automatic system of Indian family system to disseminate the past values and knowledge. Young generations, while living in their own ways and style, also kept these values and information and lived their life. This is how our society moved on and still following the path. Presently, our information technology field is changing very fast and young generation are very friendly to the technology. They can get any information by a single click of mouse. They can also get information about the past social values, culture and family system. Since the information is easily available and accessible, which earlier could be received only by a senior member of the family. In present Indian society, nuclear families are growing and it is happening sometimes by choice, where the young couple decides to live their married life alone in the name and lust of modernism and sometimes by compulsion, where earning member of family is bound to leave the home due to occupational needs and compulsion. In both the cases, senior citizens with spouse or alone are bound to live a lonely life. In first case, senior citizens are obviously ignored, but in the second case, they are not. But the consequences of both the situations are same, that is loneliness. Though the mental status of senior citizens in both the cases may vary, sometimes both the situations can be under the category of ignorance. From state's perspective, as in both the situations, senior citizens are abundant. It is also true that some senior citizens in rural and urban areas are totally neglected, mentally and physically abused, are not getting 2 square meals a day. After completion of the lesson, we should learn 1. What are the constitutional provisions for elderly in India? 2. What are the legislations passed by the government for protecting the aged persons? Though our Indian constitution categorically and specifically does not mention about the senior citizens, and it also does not contain any direct provision for senior citizen, but since it is applicable to all the citizens, therefore, all the rights and liberties provided by the Constitution can be claimed by the senior citizens as well. An analysis of the constitutional provisions has been given under which they can be protected. They are 1. Article 21. Article 21 protects life and personal liberty of an individual, but the judicial expansion of the scope of Article 21 paved the way to include the right to enjoyment of pollution-free and healthy environment, the right to health and medical care, emergency medical aid, livelihood, social security, and the right to live with human dignity and reputation of a person is his valuable asset. The rights that have been assimilated into Article 21 are from the directive principles of state policy. For instance, the rights to housing and shelter caste a duty upon the state to provide house sites to the poor houseless. 2. Article 41. Article 41 is in the Part 4 of the Indian Constitution, that is Directive Principles of State Policy. Article 41 of Directive Principles of State Policy has particular relevance to old age social security. This article says the state can make effective provision for old age for securing their right to work, to education and to public assistance in the case of their unemployment. Though it is not enforceable in the court of law and the state cannot be compelled by the courts to carry out any directive, but as per the mandate of Article 38, the state, while making any policy, shall take into consideration the directives enshrined in Part 4. Therefore, directives, though have to be implemented by the state, they could do so only subject to limitations imposed by the different provisions of the Constitution with respect of legislative and executive power. 3. Article 309. Article 309 of the Constitution stipulates that acts of the appropriate legislature may regulate the requirement and conditions of service of persons appointed to public services in connection with the affairs of union or of any state. The governments concerned frame rules and regulations from time to time laying conditions of service including retirement or terminal benefits to its employees. This article clearly mentions that recruitment procedure, appointment and service condition rules of union and states will have to pass through the test of constitutionality, meaning thereby that union and state legislatures cannot make any rule which is against the fundamental or constitutional rights of a person. So, if the conditions for compulsory retirement, rules for voluntary retirement or any other service condition which affects the rights of an aged can be challenged and struck down taking the help of this article. Supreme Court has held that if a compulsory retired person has not got proper opportunity to defend and rules of natural justice or requirements of Article 21 have not met with, his compulsory retirement order cannot be said to be valid. In the Constitution of India, Entry 24 in List 3 of Schedule 7 deals with the welfare of labour, including conditions of work, provident funds, liability for workmen's compensation, invalidity, old age pension and maternity benefits. So, union and state both can make separate pensions, rules and schemes to provide social security and welfare to the aged. Our Constitution also empowers the states under Entry 42 to frame the laws, to frame the rules and to make the schemes separately for the aged. Item number 9 of the state list and item 20, 23 and 24 of concurrent list relates to old age pension, social security, social insurance, economic and social planning. The parameters laid down in the preamble and the concepts of welfare state are the guiding principles. The state has to promote the prosperity and well-being of the people. For security and protection of an effective social order through social justice, economic justice and political justice, the state shall strive to minimize the inequalities in income, endeavour to eliminate inequalities in status and also provide facilities and opportunities. In order to secure these objectives in general and the directive to public assistance in case of old age, as laid down under Article 41, the state through its legislations has so far covered. For example, the Employees State Insurance Act 1948 and the Employees Provident Fund Act 1952. Statutory protection. There are a number of laws and measures intended to support the aged, for example, pension scheme, and these form part of the social security measures introduced through legislation. The government has realized that apart from the destitute elderly who need economic support and care through institutionalization, a large portion of economically and physically fit elderly also requires social, emotional and psychological security, and there is an urgent need to supplement the traditional family support systems at a local rather than national or state level. Though there is no specific legislation for the benefit of the elderly who are retired from the organized workforce are protected with retirement benefits, insurance for their old age as well as for their family members, provident funds and other superannuating benefits. The government has introduced a small number of welfare schemes, especially for the benefit of the elderly who are destitute and have no family support. Following are some of the legislations passed by the government which indirectly protect and promote the human rights and fundamental freedom of the aged persons. They are: 1. The Pensions Act 1871. The Pensions Act 1871 applies both to union pensions and state pensions. The word pension implies periodical payment of money made by the government to a pensioner on account of past service consideration or merit. A pensioner has complete right to his or her pension. He or she can order the appropriate government the whole or any part of his pension to be commuted for a lump sum or any part which he may deem fit. A pensioner can nominate any person to receive, after death, all money payable. The nominee then has the exclusive right to the pension. The nominee need not be a family member. 2. The Indian Succession Act 1925. Under the Indian Succession Act 1925, the father succeeds to the property of intestate who dies without leaving any lineal descendants. The property would devolve on the mother in the absence of father and lineal descendants of the intestate. She shares the property of the intestate equally among the brothers and sisters and their children if they are living. This law is applicable to all cases of intestacy except among the Parsis. In case of Parsis, the father inherits half the share as that of a son of an intestate male, and the mother shares half of the share of a daughter of an intestate. The property of Parsi dying intestate without leaving lineal descendants or a widower of lineal descendants would devolve on the parents. 3. Employee State Insurance Act 1948. The health insurance scheme was proposed by the Adarkar Commission in 1944, which materialized in the Employee State Insurance Act 1948. It provides certain benefits to workers employed in factories, including government factories and seasonal factories, in the event of sickness, maternity and accidents during the course of employment. This act is applicable where any manufacturing process which is being carried on with the aid of power and where not less than 20 workers have been working during the preceding 12 months in a factory. The employer, the state and the person concerned make contribution in order to provide for sickness, old age and other contingencies. Contributions are paid weekly to the Employee State Insurance Corporation. Under this act, the person insured or his or her dependents are entitled to certain benefits during sickness, confinement, miscarriage or sickness arising from pregnancy, disablement as a result of employment injury, medical treatment, payment to the dependents on the death of the insured person, and payment to the eldest surviving member of the family of an insured person towards expenditure on the funeral of the deceased insured person. 4. Employees Provident Fund and Miscellaneous Provisions Act 1952. Without distributing the arrangement of pension and gratuity under the Employees Provident Fund scheme, the government has introduced another mode of social security for workers who have given the best part of their life to the industry. This act has been a step towards making welfare provision for the future of an industrial worker after his or her retirement or for his benefit of his or her dependents in case of early death. The Provident Fund is an effective old age and survivorship benefit. However, when an employee dies prematurely, accumulation in the Provident Fund is too meager to render adequate and long-term protection to his or her family. With the view to providing long-term financial security to the families of industrial employees in the event of premature death, a family pension scheme has been introduced. 5. The Hindu Adoption and Maintenance Act 1956. The Hindu Adoption and Maintenance Act 1956 lays down obligation on a person to maintain his or her aged or infirm parents. Section 20, Clause 3 of this Act deals with obligation of a Hindu to maintain his or her aged or infirm parents in so far as they are unable to maintain himself or herself out of his or her own earnings or other property. Explanation to this provision states that parent includes a childless stepmother. This obligation to maintain the aged and infirm parents under this section is placed both on male and female Hindu. The obligation is personal and independent of possession of property. A daughter's obligation to maintain her aged or infirm father, mother or childless stepmother does not cease on her marriage. The word aged is not defined in this act. Therefore, it is to be construed in its ordinary meaning, that is, aged means old. The word infirm includes parents who may be young or old, and the infirmity may be physical or mental, such as lunacy, leprosy, blindness, deafness, dumbness, incurable disease, etc. The parent in this section denotes only a relationship, and thus it is not restricted to legitimate relationship. Therefore, aged or infirm father or mother or childless stepmother is entitled to maintenance not only from his or her legitimate son or daughter, but also from her illegitimate son or daughter. Where such parents have more children than one, the parent entitled to maintenance from any or all of them proportionately. The obligation of maintenance under this section extends to the following relations and conditions. 1. The persons liable for a claim of maintenance under section 2 clause 1 should be a Hindu. 2. The person entitled to maintenance under this section should be a Hindu. 3. The obligation in case of aged or infirm parents arises only when he or she is unable to maintain himself or herself. It must be noted that the obligation under this section is legal and can be enforced by a decree. The obligation in the case of aged or infirm parents continues during his or her lifetime. It must also be noted that the age of the parents is not the criterion under this section to claim maintenance. Parents of any age, even those who are not old enough and less than 60 years of age, are entitled to claim maintenance. The Calcutta High Court is of the opinion that the stepmother, though aged or infirm, is not entitled to maintenance from his stepson under this section, where the stepson has not acquired any property of the deceased father and stepmother is not childless. 6. The Hindu Succession Act 1956. In case of the death of a son, the mother inherits the property of the deceased son along with other heirs. She takes her share absolutely. Chastity, divorce or remarriage of the mother is no bar to his benefit. The adoptive mother as well as mother of an illegitimate child is covered under this Act to the exclusion of a stepmother. The father inherits the whole property of the intestate son in the absence of any other heir. He can inherit properly from his adoptive son, but not from his illegitimate son or his stepson. In the case of a daughter dying intestate, her Hindu parents inherit her property only in the absence of children and a husband. However, there is no bar to the disposition of female Hindu or of a Hindu male regarding his self-earned property. 7. The Income Tax Act 1961. The Income Tax Act 1961 provides income tax rebates in case of senior citizens, which are as follows. 1. Higher tax exemption limits. Senior citizen or super senior citizen is entitled to higher tax exemption limits against normal citizen. The basic income tax exemption limit for the both category for AY 2013 to 14 and 2014 to 15 is as under. Senior citizen of age 60 to 65 is rupees 2,40,000 and super senior citizen of 65 plus age is rupees 5 lakh. 2. Increased deductions under Chapter 6A. A senior citizen or super senior citizen is entitled to higher deductions under the following sections of Chapter 6A of Income Tax Act. A. Deduction in respect of senior citizen savings scheme. Section 80C. Under Section 80C, a deduction up to rupees 1 lakh is allowed for amount paid or deposited in specified modes. B. Deduction in respect of medical treatment, etc. Section 80 DDB provides for a deduction of rupees 40,000 to a resident assessee for medical treatment of disease specified in Rule 11 DD. However, if the amount is paid for the medical treatment of a senior citizen, then a higher deduction of rupees 60,000 is allowed. C. Deductions in respect of health insurance premia. Section 80D provides for a deduction up to rupees 15,000 for medical insurance or preventive health check. Under the section, in case of payment made for medical insurance of a senior citizen, deduction is available up to rupees 20,000. 3. Exemption to pay advance tax under Section 207. As per Section 209, where the income tax payable by an assessee for any financial year after deducting tax deducted at source is rupees 10,000 or more, the tax shall be payable in advance during the financial year itself. However, senior citizens have been exempted for payment of advance tax if they are not engaged in business or profession. 4. No deduction of tax at source in certain cases by submission of Form 15H. A resident senior citizen can receive certain incomes, that is interest, furnish a declaration under subsection clause 1C of section 197A to his assessing officer in Form 15H, stating that tax on his estimated total income of the previous year in which such incomes is to be included in computing his total income will be nil. Senior citizens can give this declaration even if such incomes exceed the maximum amount which is not chargeable to tax, that is rupees 2,50,000 and rupees 5 lakh for senior citizens and super senior citizens respectively. 5. Reverse Mortgage Scheme, Section 47. The Finance Minister in his Union Budget 2007-8 has announced that the National Housing Bank will introduce reverse mortgage scheme for senior citizens. As of now, almost all the banks have come up with this scheme. Reverse mortgage is a scheme under which a senior citizen of the age of 60 years or more who is the owner of a house can avail of a monthly income against the mortgage of his or her house while remaining the owner and occupying the house throughout his or her lifetime without repayment or servicing of the loan. On the borrower's death or on the borrower leaving the house property permanently, the loan is repaid along with accumulated interest through sale of the house property. Section 47 of the Income Tax Act 1961 has been amended to provide that mortgage of house property for obtaining a loan under reverse mortgage shall not be considered a transfer of house property and accordingly shall not attract capital gain tax. 8. The Payment of Gratuity Act 1972. The payment of gratuity is a retirement benefit in addition to provident fund and family pension benefits for employees engaged in factories, mines, oil fields, ports, plantations, railways, companies, shops and other establishment. It is payable to an employee on the termination of his or her employment often he or she has rendered continuous service of not less than 5 years. However, the payment is made on his or her superannuation, retirement, resignation, disablement due to evident or disease or death. In case of disablement and death, the requirement of continuous service of 5 years is relaxed. A protection similar to that, the Provident Fund and the Pension Fund is given in respect of the amount of gratuity. It is therefore not liable for attachment in execution of any decree or order of any civil, revenue or criminal court. It is very clear that the gratuitous payment received from the employer is available to the employee both when he or she retires by choice or due to advanced age. This amount definitely helps the retiring person to plan for old age. 9. Code of Criminal Procedure 1973. Section 125 of Code of Criminal Procedure, that is hereinafter referred as CRPC 1973, is made if any person having sufficient means neglects or refuses to maintain his father or mothers who are unable to maintain himself or herself. This provision is made to give effect to the natural and fundamental duty of a child to maintain his or her parents. This section is applicable to all, irrespective of their religion, and includes adoptive parents. The Supreme Court has interpreted this section so as to make daughters and sons, married or unmarried, equally responsible to maintain their parents. Parents can make application for maintenance against one child alone. It is not necessary that all the children are made party to such application. In this regard, the Law Commission of India, in its 132nd report, suggested that the right of the parent who has been awarded the monthly allowance should not be defeated by a son who transfers properties in order to deprive the awardee. As per Section 125, Clause 1, Clause D of CRPC 1973, a magistrate of the first class may, upon proof of such neglect or refusal, orders such person to make a monthly rate as he thinks fit for the maintenance of his father or mother. Such rate shall be payable from the date of the order or, if so ordered, from the date of the application for maintenance. If any person so ordered fails without sufficient cause to comply with order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any party of each month's allowance remaining unpaid after the execution of the warrant to imprisonment for a term which may extend to 1 month or until payment if sooner made. This provision is a measure for social justice and specially enacted to protect not only women and children but also old and infirm poor parents. If falls within the constitutional sweep of Article 15, Clause 3, that is, special provisions for women and children, reinformed by the directives by Articles 38, 39 and 41 of the Indian Constitution. This section gives effect to the natural and fundamental duty of a man to maintain his parents so long as they are unable to maintain themselves, and they may seek an order from the magistrate of the first class in this regard. 10. The Finance Act 1992. Section 88 of the Finance Act 1992 provides income tax rebate of up to Rs 15,000 or actual tax whichever is less to senior citizens who have attained the age of 65 years at any time during the relevant previous year. 11. The Maintenance and Welfare of Parents and Senior Citizens Act 2007. The purpose of this act is to cast an obligation on the persons who inherit the property of their parents and aged relatives to maintain such aged, and also to make provisions for setting up old age homes for providing maintenance to the indigent older persons. This act further proposes to provide better medical facilities to the senior citizens and provisions for protection of their life and property. This act therefore proposes to provide for a. appropriate mechanism to be set up to provide need-based maintenance to the parents and senior citizens. B. Providing better medical facilities to senior citizens. C. For institutionalization of a suitable mechanism for protection of life and property of older persons. D. Setting up of old age homes in every district. 12. Social Security to Senior Citizens Bill 2010. This bill seeks to provide social security to the senior citizens. For the welfare and protection of rights of senior citizens, several state legislatures have also passed legislations or rules, namely 1. Himachal Pradesh Maintenance of Parents and Dependents Act 2001. 2. Delhi Maintenance and Welfare of Parents and Senior Citizens, that is Amendment Rules 2010. 3. Bihar Maintenance and Welfare of Parents and Senior Citizen Rules 2012.